Honey is not a detective, lawyer, or physician, nor does she play one on YouTube. Although, she does have a Bachelor's of Science degree in education. Opinions are her own because she is stingy.
This is a true crime channel. Some videos may have content that is disturbing to some and contain coarse language. Viewer discretion is advised.
Judge Beverly Cannone, aka Auntie Bev. So her nickname Auntie Bev, it actually comes from Turtle Boy, and a lot of these people have nicknames. So if you ever watch Turtle Boy, he has nicknames for these people, and some of them I thought that was their names, or I thought, you know, that was their last name, but it usually either has to do with something they've done or just, I don't know, he's just being an ass and came up with a nickname. Like for Adam Lolly, he'd call him Lunchbox Lolly, and Auntie Bev, I will be showing you a video as to why she is called Auntie Bev. I'm not going to speak for everyone else. I'm going to speak for myself on this. I don't like her. I don't like how she conducts her courtroom. I do not like how she speaks to the attorneys. It doesn't matter if it's the prosecution or the defense. And I don't like her. Yeah. She's not a nice person. She just plays one on TV. The video I'm going to show you, it was from July of 2023. Alan Jackson, who is one of Karen Reed's defense attorneys, is talking about a motion that they are requesting for the judge to recuse herself from this case. Remember, Canton, Massachusetts is a small community. Everybody knows everybody. They are going to show her. I know some people that are kin to the people that are witnesses in this trial. And I think if you even know somebody's name that has anything to do with this case, you need to recuse yourself. I mean, why would you take that risk? Oh yeah, and that's the other thing he's talking to her about is the speed of getting responses. Judges handle things differently, I understand that. Some can rule from the bench right there. They'll be like, they'll listen to what they have to say, they'll listen to what, in this case, she'll listen what the Commonwealth has to say about the motion, and then, you know, she'll, you know, rule. Or sometimes they may take time and then, you know, a brief recess and then come back. Sometimes it may be days, weeks, months, and some of these she hasn't gotten back to them in a timely fashion, and that has been a problem. If you watch the pretrial hearings, that this has been a problem for the defense. They're not getting answers back in a timely manner. I mean, they didn't get up until like days before the trial, and I'm not just talking about her decision, but things that they've requested from the prosecution. DNA stuff, you know, wasn't tested until over a year later, and the defense just wants to look at it. I mean, it's the defendant's right to have access to that. That's the whole thing about discovery. They have to go over that so that they can prepare for their client. And frustrating. I would find myself so mad at these pretrial motions. When people are like watching the trial and they're like, oh, the defense, they just threw that in there. Well, okay, here's a couple of reasons why. The Commonwealth and the defense both told her that they wanted to wait before going to trial. They wanted to put it off. They needed more time. She said, no, we are going to have this trial when she wanted it. That's another issue that I have with her. Everybody didn't have everything, but we're going to go to trial anyways. That's a problem. And then you'll learn that some of the evidence that they've seen in trial has been tweaked. But we will cover that when I get to that part. In this video, you can tell she is pissed off. Number one, one of Karen Reed's attorneys, well, actually two, are from California. So you know she's got this thing where I'm sure. Now, this is my speculation, so I just want to make sure that's out there, that she didn't like Alan Jackson and Miss Little because they're from California and they're out here in Massachusetts. Another thing that she's done, and it pissed me off, they'll have a pretrial hearing. They'll have several to go over all these motions so that they can be ready. And I'm talking about the Commonwealth too, so that they can be ready for this trial. Now, you've got Alan Jackson and Liza Little flying all the way from California just to come for the pretrial motion. And it'll be like 1 that day. And Karen has to pay, she's paying these legal fees for these California attorneys to come out there, and that includes travel. Auntie Bev would hold, we're gonna do a pretrial motion hearing, blah blah blah, talking about whatever they're gonna talk about. It would last 10 minutes and it was over. And then she wouldn't have another one until the next week or a few days later. So it was like, because a lot of people, when they're scheduling, judges are scheduling with the attorneys, they really try to work with them. And in this case, I don't think so.
Not really sought to advance motions that have been advanced by the Commonwealth while still not ruling on motions that we've had before the bench for not just days or weeks, but now months. And it's the disparity in that treatment. Look, I don't disregard the fact that the court is a very busy court, that the court is a supervising court. The court has a lot of balls in the air. It's the disparity between the court's rulings in terms of the Commonwealth's motions and the defense motions that I think give the public pause, and that's where we need to start our analysis. Number two, the court seems to have deviated from the normal course of procedure, in this case, in order to specifically stay on the Karen Reed case. And the court only made that known, or at least known to us, to the defense, after the Commonwealth filed a request to gag the defense.
I feel like she is just holding back, and she won't look at him, and she just looks like this is annoying and wasting her time. But that's just my commentary. I really think that's the truth.
Number three, the court outright denied Ms. Reed a full and fair opportunity to be heard, if the court recalls, the last time we were here.
And that's one of the reasons that is so important to have defense attorneys, because they are there to make sure that the rights of Americans are held in place. And sometimes they're not. Well, what am I saying sometimes? A lot of times they're not. And that's what they're arguing about in this.
On a critical Rule 17 motion. And that motion was from records, importantly, from the very same family that now claims to have a personal interest and a personal relationship with this court. Troublesome allegations, troublesome claims by the family at the very least. And that brings me to the final point and dovetails into that final point. Sean McCabe, a member of the McCabe family and a brother-in-law of Jennifer McCabe, whom we have argued in this court, should have at least been a suspect. Or a
You're going to show that this way, Ms. Little. Why don't you show it to me? Thank you.
Oh my goodness. So she's already pissed off because show it to me. Please just give Miss Little some, be nice to her because she seems sweet. And anyways, so what she's got, Miss Little is about to show is a placard or a big poster of the evidence that they have that someone is stating they know Judge Bev, and they are a member of the McCabe family. Looking at the board, it says Sean McCabe was saying something that made Turtle Boy ask, do you really have a line to Judge Cannone? And as you can see, it says, Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under? Now that's not very nice. And if someone said that to me, I would have an issue. and we'd be going to court. Let's continue.
And if that weren't enough, the defense has just recently, received information that another witness, a seminal witness for the prosecution, by the name of Julie Nagel.
In video 1, I kind of touched on Julie Nagel just a little bit, but she is a friend of Brian Albert Jr.'s, who was there that night for his birthday party at 34 Fairview. And her brother Ryan Nagel was the one that pulled up to pick her up and saw Karen's vehicle. Then he and his crew left, and Julie decided to stay.
Who was Julie Nagel, Nagel, who was inside the house at 34 Fairview on the night of John O'Keefe's death. Apparently some 5 months after John's murder, and this is all public. We didn't have to do any digging and searching with subpoenas or otherwise. This was all public information. She used a Venmo app.
Venmo is. It's just an app where you can pay somebody. You can put in the description what it's for. Sometimes people just use emojis to put what it's for. In the description, Julie Nagel put Frank and Beverly. Okay, and Judge Cannone's husband's name is Frank.
As soon as a reporter picked up on that, which is how we found out about it, and publicized that, she immediately took that payment down and took it off the internet. Obviously, I have no indication whatsoever, and I do not stand before this court suggesting that there's a connection. What
I can't see that one, Miss Little.
This is simply a screenshot.
Could you bring it closer? I have not seen the previous one, Ms. Little, just held up. I know you put the other one with your...
What you're looking at is a screenshot of her having taken down that Venmo payment after it became publicized, which obviously looks somewhat suspicious on her part. These are all instances that have been the subject of public discourse, not just the defense team sitting in a room pontificating. Every single one of these instances has been something that has been in the public discourse. And the public is questioning this court's ability to maintain fairness given the panoply of information that is now before it, all in public documents that we happen to be privy to because we're part of the public as well. Nothing that we had to do any deep searching for. Your Honor, there has been an undeniable erosion of public confidence in this court's ability to be fair. But let me be very, very clear. The decision to recuse or disqualify a court due to the appearance of impartiality is not an indictment of this court's competence or integrity. It is not an indictment of this court's character. Nowhere close, and we do not aver that at all. Rather, the decision should be an expression of the unwavering commitment that this court has to justice, to fairness, to the rule of law. That's all.
I have to applaud Alan Jackson for how he is approaching this. He could have been an ass and said all this, but actually he's being super nice to maybe someone that doesn't quite deserve it.
22, what do you want to say?
All right, thank you. So I appreciate the arguments of counsel. I've considered those arguments. I've considered the pleadings, the motion, the attached affidavits, the big pack of attachments to the motions. I've considered those placards that were shown here today. A couple of them I hadn't seen before.
Okay, blah, blah. I can't handle her anymore. Okay, I'm done about her. Anyways, this right here is why I think she has behaved the way she has from the pre-trial motions to what's going on in the trial. So moving along, because I need to stay in a decent mood, and she does not put me in a decent mood.